All right, good. So for those who don't know me, my name is Lena Hung. I'm an accredited specialist with the Law Institute of Victoria and I've been practicing for over 20 plus years now. So welcome to this afternoon session on employer-sponsored visas, complex cases. Is there a bit of an echo? Okay, so just checking sound-wise, everyone can hear me clearly. Can you type in 1 if you can? And if there's an echo, can you type in 2? Just so we know who's impacted by this. So might be Hector. Okay, everyone else seems okay. But yes, let me know if there continues to be any sound issues. Okay, so this session, just some general housekeeping. As you're all aware, we're using Zoom as the platform to deliver the workshop. We've got the Q&A and the chat function. With the Q&A, you can type in questions, case scenarios, questions about your clients and looking at strategies. You can certainly put that on the Q&A. For the chat, you can send a message to everyone or host and panelists. Host and panelists are my admin staff moderating the workshop. So if you've got questions about the workbook and things like that, then post it through, select host and panelists. Otherwise, you can send a message to everyone. Okay. Now, for Omara purposes, we do take note of your login time and your log out time. So you do need to stay logged on for the entire session to be able to claim your Omara CPD points. This is a 3-hour session. We've got a break after 1.5 hours. So we'll finish up at about 4:30 Australian Eastern Daylight Savings Time. So I'm based in Melbourne. So check your time zone if you are in a separate state or if you're overseas. You do need to stay logged on for that entire session with excluding the breaks, okay? Now, if you happen to log out too early, we will contact you and let you know. So if that's the case, you'll get an email from us and you may not get your points if that's the case because you haven't completed 100% attendance. And if that does happen, we will let you know and work out some way of sorting out those points if you need those points for your re-registration. Okay. For lawyers claiming CPD units, you may be able to claim 1 CPD per hour of attendance. So this particular topic is substantive law. So this can go towards your substantive law CPD units for lawyers. So under the uniform law based in Victoria, New South Wales, you may be able to claim those units. If you are in a separate state, practicing as a lawyer, please check with your state legal regulator in terms of whether or not you can claim the CPD units for lawyers. Okay. We also have the ethics. Now, ethics, there's 2 ways of completing the ethics. One is through the private study component or online, and the other one is the workshop tomorrow combined with the other core skills. So you've got your, was it practice management, business skills, and the ethics and professional responsibility component that will be delivered tomorrow. Okay, so you can get your full 10 points for lawyers if that's the case for Victoria and New South Wales lawyers. For Omara purposes, that's considered a mandatory unit. Yeah, that's fine. So in terms of points, if you're not stayed logged on, we will let you know if you can't get your points. All right. So this is a hybrid session. We've got some face-to-face and those of you online. So for those face-to-face, you do need to just stay logged in, stay in the session, okay? Other things to note now, the materials. So those online would have received a link to our Google Drive if you have given us your Gmail email address or Google Workspace G Suite type email. So if you haven't provided us with your email address, please do that when you can. You can type it in on the chat and send a message to host and panelists or send us an email telling us what that email address is, and then we can give you access to our Google Drive in which you can then download the workbook. So just be on notice for the link to the workbook as well as the password to the workbook. Okay, those face-to-face have the benefit of a printed copy, so you don't need to give us your Gmail address. Okay, if you don't have a Gmail email address, then let us know, we'll work something out. Okay, so the materials you would have received, we also got a set of slides and some case studies. And I think that's all in terms of the materials. Any other issues, let us know. Okay, good. Now, for Omara purposes, we need to just check that whoever's logged on is logged in using the name they use with Omara. So if you can type in on the chat the name that you use with Omara, so your Mara name, the name you give to Omara, and your Mara number, and you can select host and panelist. You don't have to send it to everyone. So write your full name and your Mara number onto the chat, send it to host and panelists. That way we can identify who's who. Sometimes you're not logged into your personal account and we can't identify who is who. If you are a lawyer, just type in your name and write lawyer, okay? And those here face-to-face would have just signed in, so all good. All right, all good. So any other questions, feel free to use the chat, okay? All right, so for this particular session, I'm taking it that most of you are experienced in this area, relatively experienced, yeah, okay. So I'm not going to go through every single criteria, like line by line, that just gets probably a bit too boring. It is pitched at those with a bit more experience. If it is too hard, let me know. If it's too easy, let me know. So this way we can make sure everyone gets something out of it. Okay. So while you're typing in your name and your MARA number, we'll go through what you're going to go through today. So I guess your learning outcomes, we're going to learn about new changes and what the changes have been over the last 18 months or so, or 2 years. It's been over a year and a bit since the SID was introduced. Yeah. So we'll look at the different occupations lists, labour market testing. Not that that has changed much, but it was flagged for some change a while back. So we're hoping to get rid of it, but we still have it. So we've still got to deal with labour market testing. And some of the other requirements, like your English work experience, obviously has changed with the SID visa. And then transitioning across to the 186 PR pathway, there's some changes. There were changes with the annual market salary rate last few days ago, yesterday. Yeah, so we can talk about that. And any other questions you might have relating to employer-sponsored visas, then happy to go through that. All right, good. So I do like to start off with my pop quiz. So there's about 6 questions or so on this pop quiz. Those online, use the chat function to answer the questions. Here you can just yell out the answer. And so I'll read out each question, give you a little bit of time to answer them, and then together as a group we'll go through the answers. All right. Okay, are you ready? All right, let's get started. Okay, question 1. This is hopefully easy. What is the grant period for a 21-year-old child included in their parents' subclass 482 visa in the core skills stream? So how much time are they going to get?
Same as the parent.
Is it same as the parents, or is there an age limit? 23? 23, okay. It's either 23 or the parent period. Yes. Okay, good. And dependent. Yes, so it's really important that they're still dependent. Yeah. All right, good. Question 2. What is the grace period for the 494 visa holder to cease work for their sponsor?
The same condition.
Same condition as
180.
180 days?
Not more. 365 during.
The entire, yeah.
The whole
5 years. Yes, good, good. All right, those online, feel free to type in your answers. Okay. Okay, question 3. What is the specialist skills income threshold? How much is that now? Gone up. 140 something? 140 plus? Yes. What was it before? 135, yes. What will it be after July? Oh, we don't know. Well, we think it will be probably close to 149. About 140 something, yeah. Okay. Question 4. What are the age exemptions available under the 186 TRT stream?
20,
The Fair Work High Income Threshold. What's that amount?
80
Yeah, yeah, something like that. Yep.
for 2 years, but absolute back. It was whatever it was before.
In all the respective years. Yep. Yep.
Then there's one for academics.
Academics, lecturers,
Yeah.
yes.
Think
Yes. And regional, yes.
and
Universities.
Legacy 457, but I don't know what that's still.
Legacy 457. Good. Well, you know your stuff. Any other ones? Dharmas? Oh, yeah, there'll be some Dharma ones where
But
they've
that's
got.
not TRT.
That's
then that's a
not. That's right. Good. Anything else? 3 years, 482 being paid the highest tax bracket. Yes. So 2 out of the 3 years. Yes. On the Fair Work High Income. Yeah. Anything else? PRT. I think we covered most of them. Oh, there's another group that we haven't covered.
Another group.
So you've covered most of them. There's 2 other groups actually. 2 more. We've still got, oh, we'll go through the answers shortly so we can come back to that one. Okay. Question 5. How do English language requirements differ between TSS, SID, 186, 187, and the 494s? What's the English language level now for SIDs? Low. Is it low? It's lower than the others, yes. Yeah. Is it time of application, time of decision?
No, sorry, decision.
Decision, yes. 5 IELTS, yes. How is it different from the TSS? You know, we've got the SID and TSS, the same visa subclass number, but what was the difference in the English language?
TSS is also TOD, but it's higher.
Higher?
It's in PTE. It's
PTE, yes, there's a difference in the PTE score. Yep. TSS had different streams, if you remember.
oh yes, of course, yes. Short term.
Short and medium. Short term was 5 average.
Yeah. Medium was a bit higher. I don't know. I don't know.
It was about 5. PTE is completely different. Yes, we've got that. What about any English language exemptions?
Yes. 5
Hmm.
years of schooling.
Yes,
And where the instruction was English.
in English, yeah. Certain nationalities,
Certain
yeah.
nationalities. That's right. All of the
Any other ones? APRA, yeah. So for those with licensing registration, they'll need to make sure they meet that one. Yes. Any other ones? Any English exemptions for, let's say, 186 or 187?
passports.
Besides the passport.
Besides the passport.
187 TRT, is there a exemption somewhere? Not that a lot of people would apply anymore for the 187, but there's certainly something there to think about. If they can't meet the 186, then at least you've still got an RSMS pathway. So the English exemption, so there's a couple of comments here. Paying a fee. Paying a fee is for that second back, yeah, for the secondary. High school, finish high school in an English speaking country 5 years. Yes. Well, yes, that's part of the 5 year study. Any other ones? We'll have to come back to that one. It's a hard one because no one remembers it or no one remembers that it still exists. Okay, question 6. So when will there be ART review rights for a 482 visa applicant? Ooh, so their visa gets refused. Are they always going to get review rights? or only sometimes? Do you have to be a certain sponsor?
Yeah, so it doesn't apply to OBSs.
Not overseas business?
Yeah,
Mhm.
it applies to like standard business sponsors.
Standard, yes. Operating in Australia, yes.
Operating in Australia.
What about the nomination?
Well, but the nomination has to be appealed
The nomination needs to be appealed or approved
or approved, yeah,
Mhm.
before, yeah. But
before.
other than that, I think there's always rights, huh?
What if they're offshore
At the time of decision.
at the time of application?
Application. Uh, then
Welcome back, everyone. Sorry, we're just sorting out our tech issues. Okay, so just checking you can all still hear me and see me. Yes, fantastic. All right. Okay, so we were looking at question 6 about review rights. Uh, Okay,
you still have part 5, right? Part 5.
part 5 of the Migration Act in terms of review rights. No, which part? Yeah. Well, we'll go through those answers. All right. Okay, so question 1, we've got the 21-year-old included in their parents' visa. So if we're doing a 482, parents might get, say, 4 years on a core skill stream. The child who's now 21, unfortunately, will only get it up until their 23rd birthday. Right, so on their birthday, their visa expires. So it's happy birthday, you're now going to be unlawful after. What are we going to do in those cases?
Like TOT.
If the parents had the full 2
2 years,
years,
yeah.
but if they didn't, then
I think you could still include them.
can you include them?
No, you
No.
can't. No, well, they have to be.
They still have to be
Dependent
dependent,
child.
but they still have to be under 23. So let's say he's already 23 and 11 months, he's not going to meet the 2 years to get to the 186. The child will need to find their own visa, right? So the child will need to probably look for an employer to do another employer sponsored if they've got quals, or otherwise student visa if they're studying. Yeah. Other option, let's say it's a 494, they're regional, and we have that same situation. The parents will get 5 years, right? The child here is 21. How many years will the child get? They'll get 5 years. So the child will continue with the 5 years, even though he's over 23.
And there's no requirement for the 191 to be
Dependent. So you're better off if you're in a regional area and it's possible that they have a skills assessment, they meet the 3 years to do a 494, and you have this child situation, it might be better to go down the 494 pathway, and then everyone together can apply for the 191 because the child is deemed a member of family. Yeah. Okay, so if that's an option, that may be a bit better. It's an extra year, what, 3 years versus 2 years, but at least the child's not going to be left off. Okay, so just a few things to think about there. Okay. Question 2, what is the grace period? I think that's an easy one. 180 days. Yeah. And then 365 during the 5 years. So they just have to find a new employer, get a new nomination. Hopefully that's approved in that 180 days. Otherwise, they'll be in breach of their visa. And what happens if they're in breach or it's more than 180 days before the nom's approved? They'll send a NOIC, notice of intention to cancel, look at their circumstances. Are they working for anyone else? Have they got a new sponsor, new nomination? Hopefully they are working or find a new sponsor. Otherwise, that's it, end of the visa. Yeah, okay. Question 3, the specialist skills threshold, income threshold. So that's now 141 to 10. So the SSIT is 141 to 10, and that will go up in July. Yep. Question 4, the age exemptions. So that's 3. Question 4, age exemptions. Look at the instrument. What's the instrument number? Anyone know? So it's an old one. Yes, that's right. So 19/216. And I think most people listed the ones we've got. So we've got the academics, so your university lecturers, you've got the GPs that are regional, we've got the Fair Work High Income Threshold, which is now how much? 183,100. What were the other ones? The other exemptions? Legacy. What was the cutoff date for legacy? Legacy. So legacy 457 holders. What was the definition?
Was that April 2017? Or was there a later date?
There's two types of legacies.
Yeah, that one is a later date.
The later date.
Yeah.
So we've got the grandfathered cohort, which was the 457, yeah. What was the age cutoff for them? 50, yes. So that's the under 50. And then the legacy 457 ones were here during COVID for the 12 months between the COVID concession period. Yep. And they had to apply before 1 July 2024, I think. Yeah. I think that was the cutoff date. No more new applications for this lot, but we're still accepting the under 50 for the 18th of April 2017 cohort, which is probably not that many still there. Yeah. But those ones have the under 50. The other legacy 457s is too late now because it's finished.
They could have, the grandfathering ones could have come out and back in, but as long as they held a visa on that date, they can still do the under 50. Okay. Well,
Yeah, as long as they applied for the visa before that date.
oh,
So if they had a visa refused, went to the tribunal, it's still going at the tribunal, and then it finally gets remitted and they hold the 457 and then they move on to a 482. So you might still have those cohorts, but under 50. Yeah. Any other ones? Oh, the ones that were missing is the scientists. So your CSIRO scientists or government agency ones. So I think that they're your age waivers. Okay. And if we're looking at English exemption or English differences, we note the TSS and the SID were all time of decision, whereas your the rest of the time of application, and they have to meet that definition of competent English, which is a test done for what period?
In 3 years before their application.
3 years immediately before, one sitting.
One sitting, yes.
One sitting. So I know there's a lot of that one skill retake. That competent English is only one sitting, but the TSS, your SID, your students, I think, and your 485s might be okay because they are allowing for more than one sitting. So that one skill retake you may be able to use for your SID, but not your 186. So your 186, you want to make sure they've got competent English. All right. Okay. What else with the English language? 5-year study. Yeah. The 5-year study also applies to the 187 TRT. Right. So not that there's a lot of the 187 TRT because you have to meet the definition of transitional 457 or transitional 482. We work a definition, which is probably not that many anymore. So, but they do have an English exemption with the 5-year study. So that's the RSMS TRT, right? Not the direct entry. Yeah. And anything else? There's another group with your SID and TSS. So we've got a 5-year study. So time of decision. You've got your IELTS 5 or whatever the PT equivalent is, depending on when you sit the test. Yeah. There's another exemption. What is it? Think about a salary. The salary somewhere. Oh, 90, yeah, 96,400. And what is what else needs to be satisfied besides just the salary? So you need a overseas business and it needs to be associated, I guess. So the business is an overseas business or associated business that's sponsoring them and they're being paid this salary. So it's the intracompany transfer type. Sister company, yeah, that sort of thing. Yep. And there's one more. What's the other one? So the other one is just diplomats. So
But they wouldn't come
they might
separate.
come. Yep.
Separate.
Oh, they've got other visas, yes, but I guess you might get them here. Consular officers. Those holding a license will need to meet their licensing requirement. Yep. Okay, good. Question 5. When are we going to have review rights? So you might have the sponsorship and the nom, and then the visa stage. So assuming the sponsorship, actually, what happens when the sponsorship is refused and you've lodged all 3? What happens?
Either appeal or lodging your sponsorship.
So this one you can appeal. What about these? What happens to the nom? So the nomination, does it get refused or appeal? If it gets refused, you could appeal. If it doesn't get refused, it's gone. A lot of the time they just finalize it.
Finalized?
It's finalized, but you can't appeal it.
But does it apply to 482? So just the 407s? Because they did it with the 407s.
Both.
Both.
So if
it's terrible. But then you get a refund.
You get a refund. Okay. So what about the visa then? Do you have appeal right? No. Sure?
Actually, you do if you appeal the sponsorship.
Yeah.
Because if the sponsorship is appealed, then you can still go to the tribunal.
Yes. So in that scenario, you could appeal the sponsorship, this disappears, your visa side, because it will get refused.
Does it make much sense? You can't get a visa without a group action.
Exactly. It doesn't make sense. Purely to buy time. Because by the time they get there, it'll be like, well, where's your nomination? We don't have one. Yeah, so it's just purely to buy time, I think. What you might want to happen is lodge a second sponsorship, do another norm, because you've got your fees back. You haven't lost any of your SAF. And then you may need to withdraw this first 482. Withdraw it. And then you lodge a second 482. And then hope you get some fees back there, which you might get some fees back. So if you withdraw the first one, then lodge that one. But then you've got to sort out your bridging visas. Then becomes an issue.
I think you get a refund of the visa as well because there's no approved nomination.
Yeah.
And then you get a refund of that, and then you get a refund of the SAF.
Yeah.
You get a refund of everything.
You get a refund of everything, but you might not get your bridging visas sorted in time. Yeah. Okay. So the question or the answers provided by our face-to-face attendee was just saying you could get a refund of your nomination fees with the SAF. You could get a refund on the visa fees because you've withdrawn the visa and you have no approved nomination. So technically you're not worse off, but you will need to work out what's your bridging visa when you lodge a second nomination, second visa, because you had to lodge a second nomination. Okay? So just the fees might be okay, but it's just sorting out what to do there. Right? So you've got, so now let's say it has been approved. So your sponsorship's approved. And now your nomination's refused. Okay, so if your nom's refused, do you go to the tribunal? You can go to the tribunal, right? Or you can lodge a second nom. Can we link this second nom to the pending visa or not? No. Okay. And then your visa, you could have them refuse it, but make sure at the time of decision, so time of decision of the visa refusal, you have the nom on appeal or an approved nom. So nom is approved or the nom is at the ART. All right. So we've got to make sure we lodge that appeal. What's the time frame for a nomination appeal? 28 days. What's the time frame to lodge an appeal for the visa? 28? Same. Everything's the same. Okay, just checking. So make sure that's on appeal because we don't have the approved nom. We have the nom on appeal. Then we have review rights. Then we can lodge that. Yeah, sounds good. Easy. Or the alternatives, withdraw and relodge and then sort out their bridging visas. Okay, good. So what happens if they don't? So normally you get that 28-day letter. What's it called?
Sorry?
What's the 28-day letter called?
Oh, section.
57? Yeah, 57. So normally you get the 28 days to respond, right? Natural justice, so that you got time to appeal the nomination and then you have review rights. So what happens if you don't get that 57 requests and the nom's refused and then 5 minutes later they refuse the visa? So you haven't had time to appeal the nom.
Mm.
Hmm. Hmm. So
And
you
you
get,
don't get a Section 57 if you're offshore.
and you don't get us, or they just didn't issue one. I think they tend to issue you one.
LS. Right.
So the noms refused, 5 minutes later, visas refused, no Section 57 requests, had no time to appeal at the tribunal. You have no review rights. Full stop. That's the end of the world for that one.
That's tough.
That's terrible. Yep. Then you would write to them and say, I didn't get a 57, vacate the decision, give me more time. The decision's invalid, or you can say jurisdictional error, whatever you want to say.
Invalid?
You have to fight it. You got to fight it, either write to them, seek vacation, or go to court if you've got lots of money and time. And then they might come back and say, oh, all right, yes, we'll vacate that decision. Here's your 28-day letter.
Or you
Hopefully.
can still appeal and just wait for the tribunal to deem it
Mm.
invalid.
You could do that as well, but it's still not going to get you anywhere, right? It's just buying a bit more time, right? So less common on your 482 scenario, not getting the 57 request. More common on your 407 training visas, particularly how they would really want to just get rid of them. Yeah, so it's the training visas where you've got this issue. You might get a refusal on your first nomination. People can't be bothered appealing. They lodge a second nomination for your 407 training visa. At the same time, they've already got that 57, that 28 days is ticking. They lodge their second nomination. That gets refused. No one's appealed the nomination. Visa's refused in 5 minutes. No one's got review rights. That's it, right? And we all know about the new changes that came through on the 11th of March with validity requirements on lodging of 407. I know we're not talking about 407s today, but just remember you got to get the sponsorship and nom all approved before you can lodge the visa. Yeah. So that's not going to happen anymore with your 407s, right? I think that was one way to reduce these issues with review rights. Okay. All right, good. Any questions online that you have? So we're good to go. All right, so moving forward. Okay, so we talked about what we'll cover today. We'll quickly go through uh, the changes in the last, it's almost 2 years. So Tismit obviously has gone up. It used to be, what was it? Well, anyone remember what it was? I can't remember. It was like 53,900, and then it jumped to 70,000, and then 70,000 to 73,150. And now it's 76,515, and then it's going to jump up again in July, right? So 1 July, there's changes in all the TISMIT, Fair Work, High Income Threshold increases, and we had the new Workplace Justice Visa that came through as well. And then in October 2024, changes to the health assessments and family violence provisions being extended to 186 visas and other permanent visas, but not the 482. Okay. And then the SID visa was introduced on the 7th of December, which you're all aware of. And 1 July last year, we've got the increases in the income thresholds. And 7th of August, the changes relating to the English language testing providers. So we've got all these new providers now that never heard of before IELTS and PTE, right? So we've got these new providers, and just check the date when they sat the tests and what their scores are, right? And then 13th of September, we've got the tests available for the 482s, right? 24th of March, which was a couple of days ago, we've got the annual market salary rate changes to do with how do you work out what is the market rate when you don't have, or if you have, an Australian equivalent, and where there is an award, how do you work that out? Or if there is an award, but you don't have an Australian equivalent, what is considered the market rate? Okay, so I'll explain that in a little bit more detail because one, it is a little bit confusing. Two, the department was not following their legislative instrument to begin with, and that's why everyone's like, well, it's not any different. How is it different, right? And what happens is because some department people did follow the instrument, they refused a lot of nominations because it didn't follow the instrument. So we'll come to that in a sec. Okay. And then 1 July, we're going to see changes with the income threshold. So it's estimated to be about 79,000, close to 80,000 for your core skills stream, and the specialist skills stream at about 146,000, close to 147,000. And the fair work high income threshold will probably also go up, and we're estimating somewhere around the 191K. Okay, depending on how the department or when they release the exact figures. Okay. All right. So key features of your SID visa, which you're all aware of anyway. I won't go into too much detail, but you've got that there all summarized for you. So probably just skip all these slides because you all know about it, right? We've got two streams, the core skills stream and the specialist skills stream. Depends on the earnings. And you can have up to 4 years on the visa. And okay, let me explain market rates just so that everyone is aware of it. Okay, so the previous instrument said if you have an award that applies, all right, then your annual market salary rate would be what that award rate is, right? So if your award rate was below the TISMIT back then, well, let's say 76,515, if your award was below, it was never going to get approved, right? So if there's an award that applies and there's an Australian equivalent, okay, so let's put some figures in here. Let's say the award is 65K. So if the award was 65K, but you have an Australian equivalent and they're getting 77K, and our TISMIT or our core skills income threshold was 76,515, would that get approved? Oh, hang on. Let's say the nominee. Got to add in here, nominee. Let's say the nominee is also getting 77K. Is that okay?
According to the new rule?
No, according to the old rules. That was fine. Because you got your award, but your Australian equivalent is getting 77 and your nominee is getting the same or equivalent, that was okay, right? But if you had no Australian equivalent, which is often the case, your award's 65, you got no equivalent, but your nominee is also getting 77, under the old rules, it'd get refused. Yeah, all the
what applies had to be refused.
Yes, that's right. So under the instrument, the market rate is your award. Because you got no Australian equivalent, even though your nominee is getting more than the CSIT, it would actually be refused. Okay, so under the old instrument. But we know in practice, this is not what the department was doing. The department was going, oh yeah, I see that, but you've also put in some what we call relevant information. And the relevant information was all the job ads, your surveys, all of that. And that showed your equivalent was 77. Well, it was fine because we would use that as your market rate and your nominee's getting the same or above. Okay, we'll approve it. But this was policy. So under policy, they would approve it. Yeah. So under policy, they would approve it, but the actual instrument said, if you got an award, that is the only thing we could look at. We can't look at relevant information is that. And so a lot of people got refused. I know a lot of people got approved as well, but technically they should have all been refused. So this was an issue that through the LCA we took up with the department. And it took them a while to sort it out, and took us a while to sort out what we agreed on because people had different views on it. And because you're seeing refusals, it just didn't make sense. And so finally the departments changed the wording and said, all right, well, if there is an award and you have no equivalent Australian, then we can look at all of this and we'll decide it based on that. And that's what that change is, the significance of that change. Right? The rest of it is like, oh yeah, that kind of looks the same because it hasn't really changed much.
But that only applies to 482s or also 186s?
It should apply to both. It should apply to both. I think the transitionals said pending, but I don't think it mentioned the 186, did it? No, it only mentioned 482s. So maybe we have to get them to make sure they refer to it. But if you think about the 186s, it doesn't actually, the 186 refers to the 482 assessment of annual market sale rate. So that's probably why they don't change the 186, because it's actually, the 186 already refers to the 482 regs. Yeah. So yeah, so on the reg 2.72, I think it's like 10 or the actual 5.19.
Okay.
5.19, where it talks about market rates, refers directly to 2.72. So that's why they don't need to change it, because this changes reg 2.72 rather than the 5.19. Yeah. Okay, so for those online, we were just discussing whether or not this also changes the 186 regs. It does, but indirectly. So it should apply to the 186 nomination. Okay. All right, so questions on this chat. Let's have a look. Okay. So if we lodge a TSS, NOM and visa, but at the time of decision, SBS expired, can I lodge a new sponsorship and link to a NOM and visa? Yes, I think so. Yes. So normally, if that's the case, you lodge your sponsorship and then it should get linked to the NOM and the visa applications if they haven't been decided. Okay. Who will determine whether there is an equivalent Australian worker? So it's usually the employer, right? So it's up to the employer to put in information about who the Australian equivalent is, and if there is an Australian equivalent, then what their rates are. If there's no Australian equivalent and there's an award, then if that award's too low, then make sure you put relevant information. If there's no award, then it's pretty much any of the relevant information. What about the experience level of the candidate because they pay above award? Yeah, so in those cases, you would say the candidate has probably don't focus too much on the experience, but focus more on the skills or focus on the duties, the tasks. So the person's going to be performing these tasks that are at a higher level than a junior staff, and that's why they're getting paid more. When you say if there is an award, does that mean if an award exists, period, for that occupation, or if the employer pays staff using that award? I think it's both. Because if there's an award, the employer should be paying at least the award, but if they're not following the award, then they would need to be paying above the award. So
The contract, if the employment contract.
if the employment contract refers to the award, if they pay award rates, then it would be whatever the award rates are. But if they're paying more than the award, it should say so in the contract generally, or you just pay more and it's usually okay. So if they want to be more generous than the award, that's okay. Any issues there? Do you see any issues?
Okay. In the past, I think they would refuse like even 186s, and they would say you inflate in the award, you inflate in the salary.
Yeah.
So we never actually relied on the award, even if the award was there, because it's very convoluted. And the wording in the contract says, you know, a fair work instrument may apply, but then which part?
Which part of the instrument?
And does it?
Yeah, it might not.
So it might not.
So we tend to tell them not to put the award
Yes.
if they're not sure.
Well, hopefully
This makes it easier.
makes it easy.
Yeah. Some employers pay under individual arrangements, not pay according to award. Yeah, okay. So then I would say that's an individual arrangement. Don't mention the award if they're not paying according to the award. But yeah, then I would say individual arrangement is probably what you would pick when you're filling in that nomination form. Yeah. Okay. Cool. All right. So everyone understands what these changes are. Yeah, so, and that is where we'll add other relevant information. Yes, so add in your other relevant information. So you don't say there's award. If there is award and they are paying award, then stick to the award. But if they're not paying the award rates, then it's better to say they're individual arrangements and how they've come to that salary is taking into account all these different factors. Okay. And make sure all your salary information, surveys, job ads, are at least above the CSIT and not too high, not higher than the nominee's salary. Otherwise, they'll say, well, why are you not paying the nominee that high salary? Okay. Okay, good. All right. Moving on. Any other questions with marker rates? Feel free to post it on the chat. Other things to note, we've got the English language requirements. It's mainly the tests providers that have changed. IELTS is still the same, 5 each. It's PTE that's changed. So it was a lot easier to remember, 36 across each of the different components. Now it's up and down, so it's a bit harder to remember all the numbers for your listening, reading, writing, speaking sections. Yeah. Okay, so quick overview of the process. Nothing's really changed. You've got your sponsorship, lodge that, pay the fee. Comparing that with your other sponsorships, it's the same that you use for your 494s, so no big difference there. Working out that CSIT and the SSIT figure, it is actually written in the regs how to work it out, but you need to work out what the average weekly ordinary earnings or times earnings reference figure is based on ABS stats, which they don't release so regularly. So it is a little bit harder to work out, well, what is that base quarter or reference quarter to work out the indexation factor? So I think in the past, we worked it out to be about 4.3, 4.5, between 4.3 and 4.5. And that's how they got the increase. So I think if we apply something similar, percent, yeah, then you could kind of work it out. So that's how most people have come up to that 79 figure and 146 figure. But I think we'll wait for the department to officially put it in their, I don't know, I think they just put it on their website. There's no actual instrument, is there? I don't recall there being a particular instrument. Yeah, so we'll just wait for their confirmation. But I think between now and July, because if you're going to start advertising your LMT, and if you're planning to lodge after July, start advertising at the higher rate, right? Because if you advertise at the lower rate, it's going to be below that threshold. You might have issues. Okay, so I think 80 is probably a good figure if that's the minimum for your CSIT, and then 150 or 146, 47, 147 or 148 might be the minimum for your specialist skills income threshold, but you don't need to put the salary if your income's more than 96,400 anyway for your LMT. So, okay. Your nomination process hasn't really changed. Still got to make sure it's a genuine position. right? So this is where the department can refuse because they just don't like your client or they don't like your client's history. So we've seen refusals just because the person's been here for so long, and the department's of the view that the position is created to facilitate a migration outcome, looking at the person's history and all those concerns, right? Other things, remember to address any caveats. So we've also seen refusals because the department doesn't believe the restaurant is um, a fully, what is it called, full service restaurant, and they think it's limited service because the way the food is plated, there's no sophisticated plating, and so they think that is not.
Sorry.
It is, right? Make sure the contract is signed. So I've also seen refusals where they just haven't signed the contract by both parties.
Financial.
The financials don't need to be signed.
They're still
Well,
included in the.
you include it. Oh, yes, I've seen refusals where they've gone, oh, your financials were not audited. And you're like, well, they don't need to be audited unless you're one of those companies that need to have audited financials. I've seen refusals where they've said your document says commercial in confidence. I was like, well, so? And they said that's not the one that's lodged with the ATO. I'm like, well, you don't need to lodge your financials with the ATO. Yeah, so there are some really odd decisions coming out of the department, and I think just need to check and ask, well, have they got it right, or they probably need more training? Right. We've had some asking for registration where the occupation doesn't require registration. So there's lots of weird requests going on, right? Okay. Question. Okay. To meet the minimum 5 employee caveat for some occupations, can the 5 existing employees include the nominee? No, I don't think you're supposed to include the nominee. I think there's policy that sort of says no, not including the nominee. They haven't clarified if the 5 need to be full-time, so technically they don't need to be full-time
You
either.
can include consultants.
You can include contractors.
Contract.
So you can include a lot of other people. Just put them in the org chart. Well, probably don't inflate it too much, but as long as it's reasonable, you can see in their financials that there's a wage component that would address at least 5 employees. A lot of them require that 1 mil turnover as well, so you want to check that, and probably best not to include the nominee in that count. All right. Okay. Okay, we've moved on from the English 186 requirements discussion, but I thought with the IELTS, oh yes, the one sit resit or the one skill resit was not accepted. I recall there was some advice from MIA that said otherwise. Could you clarify? Oh, okay. So that one skill resit, it's the I know for the 482. The English instrument says you can have more than one test sitting. That's why they're allowing for the one skill resit. The 186, it's more of the definition of competent English. And if we apply Reg 1.15C, competent English, as well as with your proficient English and superior English for your GSM, it's the wording that says they sat a test and scored the relevant score, which is why it be one sitting. And so if you think about it, the one skill resit would not generally apply to the definition of competent English. And that's why that's the 186. Now, I can't comment on what MIA has said, but it might just be, the department being flexible and accepting these things because you would have used it for your 482 and it just makes sense you use it for your 186. But if you had any issues, then they would have refused it and someone took it to the tribunal, and the tribunal was to look at the definition of Reg 1.15C with competent English. It actually says a sitting. So that's where I would not risk it. Same with your GSM. So I know a lot of people are doing that one skill resit. The GSM has the same definition of competent English, proficient English, and superior English. And so you don't want to risk that, particularly if you've been dying for this invitation and it gets refused on those grounds, you'd be kicking yourself, right? So I think it's just advising clients to be aware Whether or not the department's being flexible, that's entirely up to them, but the law itself is quite clear. One test or one sitting. So you don't really want to have those issues. Okay. And I think there is some policy on the GSM part, not on the ENS part, but on the GSM, it says one sitting in the policy. So that's quite clear for GSM. Right. All right. Any other questions about that? Feel free to put it on the chat. Other things to note. Labour market testing. So there was a amendment bill that didn't pass last year, and that was to do with strengthening employer sponsorship requirements, naming and shaming employers. Well, we've got that already, but actually listing all the employer sponsors, so SBS approved sponsors on the department website, not the sanctioned ones, but just all of them. So that bill, I think, is still sitting with the still sitting in Parliament. But attached to that bill was the labour market testing part. And it was to do with extending, instead of the 4 months, you get 6 months to do your LMT. Right, so that was the change, but it didn't get through. So we're still stuck with the 4 months. Still got the 2 job ads, 4 weeks, continuous, don't have any breaks. Right? So you don't need to worry about workforce Australia. The international trade obligations. This is where the department website is actually useful because it actually lists all the countries. It's a bit easier to see rather than go through each and every single free trade agreement, which we have done, but it's a lot easier referring to the department website. So in some cases they're quite useful, and it happens to be the labour market testing exemptions. So have a look at that. The select occupation, select position, that has not changed, but certainly sort of, we'll call it flexible arrangements instead of exemptions to LMT. I think my slides are doing something. Yep, it's my internet. So just remember, if you are relying on the select occupation, select position part, my slides will come up shortly once I sort out my internet. If you are relying on the select position, select occupation, just make sure you attach that to the application. So it needs to be uploaded at the same time. Okay, so they want you to put a submission accompanying your application. Does anyone know what the word accompanying means legally? No? Where? All right, so your LMT needs to accompany your application, right? Which means you need to upload it at the time when you lodge. Yeah, before you hit that submit button.
Yes.
Yeah.
But it won't even let you proceed
In most cases, won't let you proceed. Yeah.
unless you do the manual.
Unless you do manual. Yeah. Or if you've uploaded the wrong document, it becomes a bit of a problem. Yes. So just making sure everyone's aware of that. Yeah. Okay, SAF hasn't changed. The occupations, I'm assuming most of you have now quite familiar with what's on the core skills list. Yes. So we had some new occupations added, all the cybersecurity data analyst type occupations. We've also got those travel agency managers, which were never on a 482. They may have been on your RSMS list, but even office manager. It's a new one that I think everyone's now an office manager. It's a little bit easier. So a number of different occupations, content creator, a number of sales rep roles, childcare worker, which I understand people are having trouble getting the market rates for, and your beauty therapists, travel consultants. Fantastic for those agencies that need travel agency, tour guides. Conveyancer, legal secretary. Now, for those who remember 457 back in the days when they abolished the 457, they removed all the conveyancers, legal secretaries, and so they were off the list for a good, well, since 2017, right? So, and I think they may have been on your 494 or your RSMS, but certainly not in the metro area. So I guess that's good news for conveyancers and legal law firms. Okay. And then a whole heap of occupations got removed. So your childcare centre manager is not there, but your childcare centre worker is there. Right? So it's a bit weird that some of them are, the managers don't get on the list, but the workers are on the list. And I think the cafe restaurant manager is one of the big ones that we were a bit surprised with. Yoga instructor with Italian passport. No, no. Yeah, I think, what's the yoga instructor one? Is that the India? Was that with India's free trade agreement that has the yoga? And then the Chinese have the wushu martial arts. So, yeah. Okay, for the position of restaurant manager, it is not currently on the occupations list. So after completing 2 years of employment on the 482, can we lodge the 186 TRT NOM and the visa application shortly after the 2 years employment is reached, or does it need to be lodged on the exact date the 2 years is completed? Also, how many days before the 2 year mark would be acceptable? Okay, anyone know the answer?
The position is irrelevant. The occupation is irrelevant.
The occupation is irrelevant, yeah.
So there's no list for the
So there's what? There's no
list.
there's no list for the 186 TRT. Yeah. Yeah.
The other question is,
When do you lodge? Yeah.
They're saying 5 days, not long.
Not more than 5 days. Yeah.
Do you have a problem? But if you have a problem and you have to go to the tribunal, stuff.
If you go to the tribunal, yes. So if you don't quite meet the 2 years, in the past we had to lodge on that last day the nomination and the visa, right? Now you can lodge the nom earlier because it's not confined to the 2 years, but it's just that visa part, right?
You can lodge another
round
for another occupation.
Lodge a 482 for another occupation. What, an office manager, maybe? Yeah.
Yes. Withdraw the nom.
Withdraw the nom. Okay, withdraw the visa.
Of
the bridging visa.
The bridging visa will still count.
It'll still count. Yes, maybe.
That way you meet the 2 years.
Then you meet the 2 years that way. It's probably best not to change the occupation. Would there be some?
Restaurant managers.
Yeah, the restaurant manager is not on the list, right? You might have to go for like one of the retail managers if it's retail. Fast food. And there's also the hospitality manager of some sort. I think there's another similar one, which is not quite, but similar. So the nom is not subject to the 2 years. Yeah, that's fine. A fine line with expiry when is the earliest to lodge the nom? You can lodge at any time, as long as you still hold your 482. And now that they're taking 18 months to 2 years, you could probably lodge the earlier the better. And then you've got a 6-month grace period to lodge your visa. So you could lodge at any time. All right. Okay. Good. So all these occupations have been removed, just taking note of that. I won't go through each and every one of them. And then we've got all those caveats as well. So they haven't really changed much since the TSS. So I won't go through them. All right. So all this was part of the migration strategy that was released in 2024. So part of that strategy was to introduce a clear pathway to PR. I don't think it's that clear. It's kind of clear, but there's still some uncertainty. They replaced the TSS with the SID visa. They're allowing periods of employment with other employers, also approved sponsors, to count towards the 2 years. You've got 180 days to find a new sponsor. Now, the quarterly or monthly fees. So that one, no, not yet. So at the moment, we're collecting the SAF upfront at the time when you lodge the NOM. What they were anticipating or thinking was perhaps change it to a regular payment. So it reflects how long you have that visa holder, not all up front, because if they move, change employers, you don't always get a refund. But that hasn't come through, and if it's a monthly fee, it would be actually more administrative than anything else, right? Streamlining applications, it's kind of hit and miss, like how quickly you get your noms and visas. Like some are fast.
More than this.
More of the miss, okay, more of the miss. The public register of sponsors. So this is part of that bill I was talking about that didn't pass last year. So they reintroduced it and called it combating migrant exploitation. So what their intentions are is to just list all your SBS sponsors, right? Anyone who's approved as an SBS would have their name listed on the website. It would also disclose, so the name of the sponsor, ABN, how many positions or what the positions are. So if you've got a cook, a chef, it would say cook or chef. And if it's a small business, you could probably work out who that person is, right? And so it will probably be used by recruitment agencies where they're going through each employer and saying, I know you're a sponsor. Would you like to sponsor ABC? So uh, and then it opens up for people to misuse that information to probably try and scam an employer to say, oh, we're from the department, or we know you've got a sponsorship, and there might be some other things that they might put in there, like collecting fees or things like that. So you never know what it could uh, be used for. But the idea is to list who the sponsors are. So that hasn't come through yet, but it is part of that bill. Okay. Other parts to the migration strategy, they promised 7-day processing for the specialist skills pathway. I think it happened for maybe 2 weeks, and then after that, it's been pretty hit and miss, more of a miss. Monitoring of the salary, so where I would say they are monitoring sponsors, but whether or not they're monitoring salary for the new lot, I'm not sure yet. Okay, but just be aware if you've nominated the high salary, you've got to make sure you're paying them that high salary. Otherwise, it'll be a sponsorship obligation issue. Okay. Under the core skills pathway, they've sorted that out, but we have not seen any movement on the essential skills pathway. Nothing.
Yeah.
Nothing. I guess you just use your labour agreement for now, but see what happens. Okay. So they've covered most of that. And okay, case study. All right.
Are we going to, sorry.
Yeah.
If I'm jumping ahead, but the work experience, 12 months, is it later?
Oh, we'll get to that on the
We'll
visa
get-
side.
okay.
Yeah, on the visa side. Yeah. So let's do a case study. We've got Martin from Spain, and he's come to Australia on a e-visitor visa, finds work with Hungry Hippos restaurants. He's offered a position as a manager. All right. So I haven't specified what type of manager. That's something you need to work out. So he wants to work immediately. The sponsor is already approved. He's got his CV that shows 5 years of experience as a restaurant or bar manager. Not much evidence of the experience, and you've got his PTE results. Okay. So the company seeks your advice on the nominated occupation. Right, and you then do your LMT, and he's now on his A nomination. So they've lodged the nomination. Nominations refused, contracts not signed. What can you do? Okay, so a couple of questions. What was the nominated occupation for the business? So what occupation would you choose? Can he still proceed with that 482 visa now that the NOM's refused? So what happens to the review, if he has review rights or not? Can he lodge another visa if he's on a bridging visa? Can he start work? Are there any other issues, any other options? So I'll give you about 10 minutes, those online, use the chat function to communicate with other attendees. I'll have my mic on mute and camera off. We'll come back in about 10 minutes and go through the case scenario. So I'll see you soon. All right, welcome back. So we're looking at the case study. So we've got Martin, who's here on his bridging visa now. So he's lodged the application, nom's been refused. So what was the occupation that we could pick from? It's very limited because we don't have that cafe restaurant manager anymore. So some suggestions here, retail manager. So the manager would usually be in a fast food setting. It may work, may be risky, hard to say without seeing the PD and the org chart. So retail manager, retail trading establishment. So we've got to know a bit more about this Hungry Hippos restaurant. So if it's in that retail setting or fast food setting, then it might be okay. There's another one, I think was um, hospitality manager of some sort. So you'd have to check if that hospitality retail service manager, not elsewhere classified. Yes, I think that's the other one that you could look at. But if it's yeah, hospitality, retail, and service managers not elsewhere classified. Then you have to explain how it's not a restaurant because the department will clearly see it's a restaurant. So, not easy. You just have to warn your client that whichever occupation you pick is going to be looked at carefully. And so, if they've done their LMT, the nom was refused because they didn't attach the contract. Would they be able to appeal that decision? Can they appeal? Change the name of the restaurant is another option. um, can you appeal the nom? Yeah. Okay. What about the visa side?
Yeah.
Yeah. Should we appeal the visa or let them refuse? Or is there another option? Could we withdraw and relodge, or just let them withdraw? What about his bridging visa? And then apply for another one, get a B, tie it over to the new application.
Still have no work.
No work rights. When can he start work then? Never. Never. He's probably not going to get the visa. No. Okay, so he can't start work.
Well, I mean, you can request waivers, but will they give it?
He can request work rights, yes. Depends on his bridging visa. He still has substantive visa. His substantive visa's expired now, so we're going to be stuck with it, with those issues. Any visa requirement issues? Like, does he meet the visa requirements for the 482?
In the PT. Well, yeah.
PTE? Is his PTE efficient or not? Does he need to sit another test? He might need to sit another test, depending on which date that was. Yeah. I think it's below. You need 36, don't you?
Jeez.
Or 20. So it depends when he sat the test, but
But it's still below because
still below.
aging is 6.
Yeah.
And here it's 30. So
Resit.
but he's okay to lodge. He just needs to
Pass the test later.
test.
Yeah. Work experience? It's got 5 years. No, not much evidence.
Well, yeah, there might be an issue there.
Yeah.
If there is no evidence.
So I would appeal and let him work with the employer for 1 year to gain the 1 year experience at a time. Ooh. Well, he can't work. He's got no work rights. So he can't work during that time. He could ask for permission to work, but then the 1 year work is at the time of application, right? So it's no longer at time of decision. So you then relodge everything again once he's got the 1 year experience. Yeah. Okay, so any other visa options? Spain.
Maybe another
It's probably old, too old for working holiday.
work for working holiday. Leave and get a 400, maybe.
Leave, get a 400, what, highly skilled?
With the you can get one. And
Because it's highly skilled. For a painter, okay. Niche. Maybe he's got other options.
Like
Come back
the
on a visitor
GT,
visa.
the GT.
GTE. 407 training, maybe.
Not possible.
Well, he has to go offshore and sort it out. He can't do it here. So go offshore. He could come back on another e-visitor. He's not unlawful. He hasn't got any ban, so he's got a few options. All right, I think we are due for a break. So let's have our break. I'm trying to find my break slide. Here we go. Come back at 3:02 Eastern Daylight Savings Time. So those online, check your time zone, but come back in 15 minutes. Stay logged on if you can. If you happen to log out, please log back in before we resume. So we'll see you in 15 minutes. I'll have my mic on mute and camera off and see you soon.
system, but I think that's we take after it French. Yeah.
Because in Vietnam, you can, I mean, they are companies. This is definitely um,
Okay, welcome back. Hope you all had a good break or had something to drink or eat. Okay, so there's a couple of questions on the chat which I'll get to because we will talk about the 186 TRT and changing employers or counting employment with a different employer. So we'll talk about that shortly. Any questions about Martin and his visa options? Or we note that he could probably go offshore and relodge something. And in terms of a restaurant manager role, he has to pick something that is on the list. Unless he gets paid 141,000. Is that realistic for a restaurant manager? Be quite high. I think it'd be, unless it's like fine dining and they very exclusive, high turnover, maybe, but no, I think it would be a bit harder. Okay. All right, let's have a look at Greg's case. So this one involves a 186 nomination TRT type scenario that hopefully might answer some of the questions on the chat. All right, so we can do this one together. So Greg applied for his 482. So he's got that from December 2024 until December 2026. All right, so when he applied under the TSS as a cook, that was on the short-term stream, which was only 2 years. All right, so he had a 2-year visa, and that's why his visa expires exactly 2 years. But he stops working and changes sponsor. So there'll be a gap here where he's not working for his employer and he's waiting for that new nom to be approved. So new nom. So how much time can he stop work for his employer? What's the time frame? What's the time frame? When you stop working, how much time do you have? Grace period?
180 days.
180 days, yes. So he's got about 6 months to make sure his new employer sorts out the new nom. But yes.
Oh, there was something, I think in the MIA that basically the department said as long as the nomination is lodged and it's the same occupation, then the 180, then he's not breaching the 8 whatever
607.
607.
Yeah. So there's, I think, a couple of things to this. One is you've got that condition, right? So you've got your condition 8607 that says you got the 180 days, right? Then the other thing to think about is your 186 TRT requirements. So your TRT requirements are what? Is it 2 years in the 3 years immediately before application? Right, and he's only got an exact 2-year visa. Okay. So to comply with the 180 days, technically he needs that NOM approved within 180 days to comply with that condition, technically. But for your 186, they're saying we can count the time you spent with your employer once they've lodged the nomination. So they're actually two different things, because the 180 days is a condition. The requirements for your 186 is just saying, yeah, we can count period spent with your previous employer. And we could count it from that date rather than the approval date, right? So if we're going by strict condition 8607, it would be once it's approved, you want to ensure it's within the 180-day time frame. We know that there's delays with nomination approvals, but technically when you're doing a transfer, they're supposed to process that faster than other applications. But if there's more, if it takes more time or they took a long time trying to find that second employer, it's not going to be approved in 180 days. They're actually in breach of their visa. But the department's probably not going to take action because the delay is caused by the department, right? It's not caused by the visa applicant themselves or visa holder themselves. So that's one issue. If we're looking at, okay, we've resolved that condition, he's not going to lose his visa for breach of condition 8607. Can he meet the 186 TRT stream? Because we need 2 out of 3 years while you hold the 482, right?
Or so it says.
Or a bridging visa that relates to one of those. So here we've got a gap. Is he going to meet these requirements for your 186 TRT? No. No. Simple answer. Okay. So what can we do? Lodge another one. Which one would we lodge? We could do another 482, right? Give him more time, stretch it out. Could we still lodge a 186 TRT?
Yes, withdraw.
Withdraw?
I'm not sure you can.
Should you get a refund?
You don't get a refund for a TE, but I think you do for TRT.
Okay.
Don't quote me on that.
I'm not sure if you can get a refund. Just trying to think when we get a refund. I feel like the refund provisions are really limited for the 186.
Then we just lodge a TRT. We'll lodge the NOM for TRT anyway.
You lodge that anytime.
Anytime.
Yeah. What about the
Then-
visa?
It's whatever is cheaper.
Which is cheaper. Okay. So you would lodge
Could
two?
You could lodge, no, well, you could lodge a 1 year 482
Yeah.
with a SAF
Yeah.
for
Uh-huh.
1 year.
Yeah.
And so that'll be,
Um,
well, presumably 1200
mhm.
plus 330, so that's 1500
Mhm.
plus
The visa fee.
the visa fee. And does Greg have a family? No,
Okay.
Probably
Yeah.
not.
Probably not.
so it's 3.2.
Mhm.
If he lodges a 186, it will be much more
Mhm.
because there's 3 SAF plus. Well, the nomination is lodged anyway, so
Nominations there. Yeah. But
then if the yeah, I think the 482 is still cheaper.
so you could do the 482, get another year. So that ties him over to fill the gap to then meet the 2 out of 3 years. That's one option. Another option is still proceed, but then you're going to have to lodge 2 of them, right? So you lodge one, get onto the bridging visa,
Another one.
lodge another one once you've met the 2 years. Okay. Any other options?
I mean, direct entry.
Direct entry, yes. Previously it was not available because
Cook's.
Cook was not on the list, and now you can, right? So it's
Yeah,
just
but he needs skills.
he needs a skill assessment. Yeah. Okay. So direct entry is probably easier. A couple of comments. Let's see if we can answer this question. So to clarify, period of employment counts with any approved employer. So if the nominee ceases employment with the first employer and then finds second employer who is willing to sponsor them, and the second employer lodges the SBS and nom at the same time, can the nominee work for the second employer while those applications are being processed? Yes, so they've got that 180 days to do all of that. If so, can the period of employment with the second employer be counted towards the 186 TRT employment requirement? Yes. So the idea of the change with the 2 out of 3 years is that you can count the time with your second employer, and the policy is you could count from the time you lodge that second nom, but technically it should actually be the time the second nom's approved, but for the sake of what the department's telling everyone, you could count from this point in time, but the regs kind of say approval date is probably the more accurate date, but they don't want to disadvantage people because it can take time to process that nomination. So they're allowing them to count from the time the nom was lodged. Okay. So you could lodge a 482 for 1 year, but what if the department is still processing the 482 after 1 year? That's still okay. You just have to lodge when you meet the 2 years for your
Withdraw the nomination, get a refund of the.
withdraw and get a refund.
Get a refund of the.
You're very good at these refunds. Get your money back.
But that takes, well, they take 8 months.
They take a while, don't they, for that? Good. Now, a couple of other things to think about. What's the processing time for your 186s?
For 18 months, 2 years, sometimes more.
Yeah, right. So you're looking at 18 to 24 months. Potentially. Some are a little bit quicker if they're regional or health sector or something, right? Yeah. So you're looking at 6 to 12 months. You lodge your 482. Right. So we're looking at, we paid 1 year SAF 482. We're going to get 1 year on that.
Yeah, if it's approved.
If it's approved. So when we're at this point in time, we lodge the 482. What's our status? Our bridging visa?
BBA.
BBA. Okay. So we're on a BBA. We keep working, get the gap filled, and we lodge our 186 TRT. What do we get here?
C, but you can apply for an OD.
Okay, so you could potentially get a BBB if you wanted to. Right. Okay. So this, say, takes 2 months, 3 months to process.
But the C will come with work rights because it's an application for TRT.
So you get work rights here, your B will get work rights.
Yeah.
But you still got your A.
Yeah.
Well, your A becomes your B or whatever it is.
Yeah.
Right? 482 gets granted.
Then you're on the 482.
You're on a 482 with 1 year. Your 1 year.
Lapses,
This takes 2 years to process.
when it lapses.
When it lapses.
Yes, a BBA. Yeah.
Are you sure?
That's a good one.
So we did the right thing to get more time. And yes, we got the A, and then first opportunity, we apply for your 186, we get the C, but we don't care because we've got the B and we're sorted. Our 482 gets granted, but we only paid 1 year SAF. It's now approaching this time. Your 482 is going to expire. And we're close to the processing of your 186. We've got like 6 months to hold on, but what are we going to hold in that time once your 482 expires?
Saying nothing, right?
I'm saying we have to think about this because I've got an exact case and I'll tell you how bad it is.
Okay, but
What bridging visa can we get? Yes?
you applied off a substantive visa.
No, you weren't. Remember?
Ah, yeah, no, of course. Okay.
We didn't hold a substantive visa at the time.
Yes, and the original visa was linked to the grant to the 482, which becomes granted.
Yeah, yeah, yes. What happens to bridging visas once a
So we
substantive
want the
visa?
482 to be refused.
You wanted to be reviewed. That probably would have been a better option, right? To get a refusal.
Yeah, and then go to the tribunal because then it kills the grant, kills the BV.
The grant kills the BV, yes.
But if you apply for a B in the 186 application, it doesn't get killed.
How do you get a B?
When you had an A associated with a lodged 482, so you meet the Schedule 1 for a B.
Do you? What are the requirements for a B? Okay, let's go. What are the requirements for an A? So why can't we get an A?
Because there's no substantive.
Because there's no substantive. So the only way we can get an A is at the time when we lodged this visa, we held a substantive visa. And because we didn't have a substantive visa, we can't get that, right? Okay. So why can't we get a B?
Well, we can.
We can't. Not at the moment, right? We can't get a B because to get a B, you must hold a BVA or BB. And we actually don't hold any bridging visas.
No, okay, sorry, yes, but I'm saying when you apply, when you get granted the C,
We've got the C, yes.
you still hold the BBA if the 482 hadn't been granted then.
Yeah, but the moment your 482 is granted, everything ceases. All your bridging visa ceases. So that C is gone, your A is gone, your B is gone. So you actually don't hold any more bridging visas.
But why? Because the B is linked to the pending 186.
But the B ceases upon grant of a substantive visa. Any substantive visa.
Are you sure it's ceases or is it just dormant?
It is.
Then you can resuscitate.
Resuscitate. To resuscitate your Schedule 1, you still need to hold an A or a B. You don't hold an A or a B. The only way you can get an A or B is to apply for another visa, 482, or someone suggested a visitor visa, so that you can get an A and then you can do the B. But that's more cost just to buy this extra time.
Yeah, it's either that or nothing.
It's either that or nothing, right? How about a C? Can we get our C back? C, you can get it back, but you have to wait until you're unlawful. You can only get it when you're lawful, or you don't hold a substantive visa. So because you still hold a 482, you can't make an application for the C. Like you can make a valid application, it just can't be approved. You'll get refused because you hold a substantive visa and not hold a substantive visa.
But how do they then do it with parent visas? Because
Parent visas? Which bit of parent visas?
you, for example, apply for a, I mean, okay, I don't know.
Yeah, any like the age parent?
Yeah, like
Yeah, onshore. Yep.
onshore.
Yeah.
Off a tourist visa.
Yeah.
You get an A.
Yeah.
Then that A, they don't apply for a B, and so they have to leave. So that then they re-enter on the e-visit on the tourist visa.
And they can get their A
They
back
get the A back.
because they have
But
a.
if in the meantime they get another tourist visa approved, they can. I think they can still get the A back.
Yeah, you can get the A because at the time when they lodged, they had a substantive visa. But this one, at the time you lodged, you didn't have that substantive visa. That's the only. That's why. So this is where, even though we were hoping it would be processed within time, we're now stuck in a situation where visa's going to expire. We're still waiting for the 186. Can't get an A or a B. We can get a C, but I don't like wanting to wait until they're unlawful to lodge a C, and then that's going to impact on their citizenship. So it might be convincing another 482, which is going to be difficult. The other suggestion was a visitor visa. Issue of visitor visa is you have to withdraw straight away. Otherwise, we get refused. Or if it gets granted, you've got no work rights. So there's a lot of complexity there.
If you withdraw it, then the C, you get a C, another C, right? Before no.
If you withdraw it, you can do that B thing.
You held a B all the time. No, you have a 482.
You have a 482. So if you have a 482 and lodge a 600, then you get your A.
Then you just
Yeah, and then you do your B. Yeah. But it's just that risk of refusal quickly or withdraw.
and withdraw immediately.
Yeah. That's probably the only way, which
But
again
then
is going to be
B
expensive.
Yeah, but then you need to link the B with the TRT.
Yeah, yes.
You can't leave the A.
No, you can't.
Because then the A dies.
The A dies, exactly. And then you have to hope that they grant the B within the 35 days because you've withdrawn your 600. Tricky, right? So I feel like advice is wait 2 years, just in case, because your 186 is taking so long, right?
You have to sell it.
Oh, it's so difficult trying to sell these things. And the cost of a 600 is like $500 per person, plus your $700 fee because you've applied and you've got a family of 4 or 5. They're not going to be happy with that. So, yeah. All right. All good. Let's have a look. So a couple of comments. A cease, can't get B, so whilst holding A, cease within 35 days, lodge another substantive visa, which 600, for example, reinitiates the A, which allows to lodge a 186 TRT. Yep. Can I apply for a B based on the 186? Yes, once you hold the A, then you can do the B. Game of cat and mouse over 2 to 3 days. And it worked. Oh, okay. I'm glad it worked. All right, so hopefully the department doesn't delay the bridging visa grants, noting that the department does delay bridging visa grants, particularly for some cohorts. So, yeah, okay, good. So not easy, a lot of things to think about. It works in theory, in practice is another issue. No, okay. All right, English language, you all know about. I'm just going to quickly go through some of these other slides that you should all be aware of anyway. So the visa side, it's the 12 months work. Okay, so the requirements for the work experience is time of application, not the 2 years time of decision anymore. So you have to have that experience. It can be part-time, casual, full-time equivalent, and it just says related field, isn't it? So in the occupation or related field. So if you've got the different ANSCO codes, but still the same field, I think it is arguable to say some work is related. So I think there has been some examples of cooks and chefs. I think going from cook to chef might be a bit harder because the department thinks they're different skill levels. But if you're going from chef to cook, I think that's okay because it's same field and you're going down a level. So it's assumed you have the experience at the higher level. This is in your 482.
It's just in the schedule 2.
In the visa.
The visa itself.
Yeah. Okay. So in the past, when it was time of decision, I think a lot of people just waited out, hope that if it got refused at the tribunal looked at it. Yeah. Now we can't do that. Right. Okay, English, you're all aware of. No more GTE, which is good. And work conditions, the 180 days. Okay, there's a couple of case studies which I'll skip. All right. Any other questions about the SID visa itself? No? Okay, so moving to the 186 part. The main thing is the nomination can be lodged anytime, right? Previously, we had to lodge on the last day because the nom regs said you had to meet the 2 out of 3 years while holding the 482 at the time of nomination. Now it's not there, so it's still at the visa stage, right? So that's easy. Market rates, all that's the same. Lodging the nom is the same. So your reg 5.19 is really you must hold the visa. So you hold the visa, it doesn't say you have to hold it for 2 out of the 3 years, right? So hold a 482 or a bridging visa linked to 482 or 186. And the occupation doesn't need to be on the list. So your restaurant managers are fine, provided they've done the 2 years, 2 out of 3 years. So the nom requirements are fairly straightforward now. You don't have to list family members. Have you noticed that?
Yeah, in the nom.
In the nom, yeah. And do you know why?
Oh. There's something with visa itself that doesn't require them to be listed.
Oh, you got to list them in the visa.
To be listed.
Yeah.
You don't have the approval.
It's a weird one where the department's gone, oh, we realise we don't actually need to list the dependents on your nomination because the employer's not bound by it. So,
but you still need the employer's consent to include them in the 482.
For the 482, yes. It doesn't quite make sense because for the 482, you have to show, yes, the employer's happy to extend their sponsorship obligations for them.
That's why, okay, because the sponsorship obligations don't
extend to... They do extend in some respect. Yeah, which I thought was a very odd one. Like, okay, there was no harm in listing them, but now you can't list them at all in the nomination. Yeah, it's a strange one. I think their focus was probably on the direct entry part where you don't have to be a approved sponsor, and so there's no obligations in that respect. Yeah. Whereas your TRT, yes, you've got to be a sponsor at some point in time. Right. Okay, a couple of questions. Does the 186 TRT only require 2 years of work with the same employer? No. So it doesn't have to be the same employer, but you do need 2 years of work on the 482. Sponsor may go into liquidation while TRT is processed. What will happen to the applicant? I think that's it. If they've got a pending visa, it's not going to get approved if the sponsor is no longer operating. Well, it depends on if they come out of that liquidation, probably not. If they are no longer operating, they're not going to meet the nomination, and the department will refuse it unless you withdraw it because they'll see there's no position available for the applicant for the next 2 years. So that's end game for them. They have to find another sponsor and do a new 186, or they'll have to go back onto a 482, depending on where they're at. If they're on a bridging visa, or could probably count time on a bridging visa. That might be okay. Maybe. Right. Okay. So the different cohorts of moving to PR, we've still got the grandfathered cohort. The main thing is they've got the age up to 50. The others are all at 45. So everything's at the visa stage, okay? So we have that, I guess it's like Greg's case. You've got the 2 years. You've got to hold a 482. So with your nomination, you could lodge your nomination at any time. So you could lodge it earlier, 186 nom. The main things under Reg 5.19 is that the person holds the 482 or bridging visa linked to it. That's pretty much it. Besides the business requirements like actively operating, meeting annual market salary rate and those sorts of things. But you could lodge on the fact that the person holds the 482. And then on the visa side, TRT, you have to hold your 482 or bridging visa, and you have to have held it for 2 out of the 3 years. So if you've only got a 2-year 482, I think the other questions before were, do you lodge on the last day or not? And then the policy is 5 days earlier, not more than 5 days. The actual Acts Interpretation Act is, what is 2 years? What date is 2 years? How would you treat it? So let's say your visa is granted on 1 Jan 2025 and it's up until 1 Jan 2027. So what is 2 years? Is it this date or is it the 31st of December 2026? What is it? It's actually 31st. So if you lodge on the 1st, 2 years immediately would be, you would meet that definition. Yeah. Provided the person worked on the 1st, right? If the person worked on the 2nd, then you're not going to meet the 2 years, right? So when you're looking at 2 years immediately is actually the 1st of Jan to the 31st of December date, not the 1st. So you can lodge on the last date and meet full 2 years. Okay. I had one a while back. So this is pre all the policy. The person lodged on the 31st, like let's say on that last day, but they lodged at 9 p.m. What do you think happened?
The workday will have finished, so they will have worked for 2 years.
So technically the work date's finished, but you haven't met 2 years. So you had to actually wait till that day. And the tribunal was of the view that you lodged 3 hours too early. And that was it. And then the minister intervened, but only granted her a substitute visitor visa. And so she then had to go through the whole process again. Yeah. Waste another 2 years. And then we had this age issue. And I was like, oh my God, it's like issues galore. But it was because of that, you need to wait until it ticks over because they didn't have the policy was not clear on a few days. Right now we've got the few days that might be more helpful, but the tribunal was of the view you're 3 hours too early. It's pretty bad, right? So unless it's WA time, then yes, 9 p.m. WA time. Yes. Yeah, so just be aware that technically 2 years would be okay if you lodge on that last day. But if you want to rely on policy, you've got a few days to play with. Okay. Any other questions, issues? Okay, applicant lodges 186 and is on a BBA, but employer makes the position redundant. What are the options? That's it. Another end game. You've got to find another employer. Go on a, well, you have to find another employer because you've got no position, right? So
But it'll the experience.
the experience could still count, yes. So because we can count the time with another employer, another sponsor, then we're okay, right? Okay, so the change in the 186 TRT, you've got 2 out of 3 years. You need to hold a 482 or an old 457 or a bridging visa related to those applications. for 2 out of the 3 years, right? So you can hold that. And then with the work itself, so pre the change, it just said employed in a occupation. So they weren't clear on approved sponsor or any occupation. Didn't have to be on the list. You could be driving Uber potentially. That's still employed in an occupation. And that would be your 2 out of 3 years, right? And then the department's going, okay, we need to add in the words an approved work sponsor, right? And then that's created more confusion because it's like, well, does the approved work sponsor still need to have their valid SBS, which the department says, no, but they have to have for that. Yeah, so they do need to be an SBS. It's just the employment doesn't have to be undertaken while they're an approved sponsor, but obviously because they're going to take over the visa, you need a nom and approved sponsor anyway. It's okay that you could count the time they were before an approved sponsor as long as you ended up getting a nomination approved, right? Then there's another confusion to this. So if you read it, it says, you know, they're made employed in an occupation in relation to the visas in A, B, or C. So if we go back to A, B, or C, so A is a 457, B is a TSS, C is the SID visa, and then D is where we've got those bridging visas tied to the 482s or your 186 or your 187. Right? So here where we need, let's say we need the extra time, like just say we need another 2 months to get to the TRT part, like Greg's case, for example, we need more time. And we were saying we lodge a 482 and then another 186. Or we lodge 2 186s. There'll be a time when we're holding the bridging visa. Right? So we've got your 2 out of 3 years where you hold the 482 and let's say 2 months on a bridging visa tied to either a 482 or a 186. So we meet this part where, so reg 186.226, we meet that. Are there any issues when we look at 227 that says the work or the position needs to be in relation to a visa in A, B, or C? So what about the work that was undertaken on the bridging visa? Is that saying it doesn't count? Or do you read it as it's the position, not the visa? But then why would they mention the visas? It says in relation, right? So there's been some confusion amongst agents and lawyers where they're saying, well, you could only count the work while on these visas, but then that doesn't make sense, right? Because you've already got that there. The concern is the extra time you have to make up the 2 out of 3 years on the bridging visa. I think it just needs to be reworded because it makes it sound like you could only count the time on your 482 or your 457, not the time work on a bridging visa, which I don't think is the intention, but it could be easily misinterpreted to say that you could only count work that was employed while holding these visas, but I don't think that's the intention. Right? Do you get it? Like, it's a little bit confusing. The bridging visa was in relation to one of these other visas. Yeah. Okay. So I think it's how that's interpreted. I don't, for those who are a bit worried about what that means, if you were on a bridging visa working in that occupation and you're counting time on the bridging visa, I think Reg 186.227 is not intended to exclude that time on a bridging visa. It's just it just needs rewording, I think. The wording of it is confusing. Okay, so be aware of that. Okay. Any other questions on the 186 TRT. I think most things are pretty clear. Direct entry, we've got the occupations and the English tests that are available, which I won't go through too much. And the age exemptions we talked about already in the pop quiz. And English exemptions, there's no really any English exemptions unless it's a RSMS TRT stream. And skills assessments and an RSMS, which very limiting. Don't think there's a lot of people eligible anymore, though there might be some who are still transitional 457 or 482 workers. But note those changes where we talked about not lodging the nomination early for 186 is only available for the 186. So any RSMS ones, if they meet the transitional 457 worker or transitional 482 worker definition, they still have to lodge on that last day, okay, for RSMS. Okay. Any questions about ENS, RSMS? We're good. Any questions online? Does the 186 direct entry require 3 years experience with any number of employers, including overseas experience? Yes, yes. So DE can be anywhere. It doesn't have to be in Australia. It can be overseas. It can be with any number of employers. Okay, so that's fine. Is the English requirement for dependent? Only for the second visa application charge. So if the dependents don't have functional English, then they have to pay that $4,980 or so, whatever the fee is. Yeah. If the nominee is currently paid in accordance with the relevant industry award, level 1 for Educational Services Teachers Award, but still below the TISMIT, will this still satisfy the requirements for 482 norm? No, they're paid below, so it's currently paid according to the award, and the award is below TISMIT, then it'll get refused. Yeah, so no, unfortunately. Okay. Any other questions with TSS or SID, 186s, TRT, 186 direct entry, RSMS, TRT? We don't have direct entry for RSMS anymore. 494s hasn't changed at all. So same process, same occupation, same regional areas, same skills assessing body, English, slight changes with the providers, and conditions are still the same. You've got the 3-year limitation on applying for spouse visas on your 494s. Comparing the different visas, employer-sponsored visas, no major changes. Yeah. I think the major difference is probably the work experience. So the 12 months for the SID, TSED has the 2 years. Your 186, 187 is 3 years skilled full-time work. Or if it's under a labour agreement, then it's under a labour agreement, which can be easier. Question. Australia just signed the free trade agreement with EU. Does it mean no LMT requirement for EU countries? Have to check it, right? You have to check what it says. So we'd have to check that. And then if there are no LMT requirements, they need to update the instrument to include it. And then we've got to go through. They haven't updated the instrument. So at the moment, we still have to do LMT. We'd have to check the free trade agreement to see if it says anything about LMT. Yeah, weren't all the beef farmers upset and other people are upset, but all the cheese people were happy. But we'll see if immigration lawyers are happy or not, or RMAs are happy or not. We'll just see. But some countries are already exempt from LMT. Who's from the UK? Who else is in the European Union that are exempt? No one? No one. I thought there was. We'll have to check, but we'll see. I'm sure once someone's looked at it and the department's updated their instrument, then everyone will know. Yeah.
You had a list of
We had a list, the department website. You just check the
Yes.
department website. Okay. Hong Kong passport holders or British national overseas passport holders have that 5-year visa and they can transition across the PR quite straightforward. I won't go through it in too much detail. Have it there. All right, let's have a look at case study. I'll give you about 10 minutes or so to have a think about this. So we've got John and Jenny. They both held 482 visas, which expired last week. But 2 months ago, Jenny gives birth to George, so their baby. But prior to the expiry, they applied for a further 482, but didn't include the baby in the application because he didn't have a passport. So George now gets his passport and wants to be included in their application. So how are we going to include George onto the 482? And then what would your advice be if it wasn't a 482 but a 186? And is it any different with a 494? So I'll give you about 10 minutes. Have a think about all of this. Work out what's the best way to resolve George. And I'll turn off my mic and camera and we'll come back shortly. And you can use the chat function to communicate with other attendees online. Okay, welcome back. All right. Oh, good. We've got some answers here, which is great. Okay, so can a child of a 482 visa holder still be included as a dependent on a 186 TRT if over 23 years at the time of application? So provided they still hold their 482, which they may not if they're over 23, unless they're incapacitated to work and that's why they've still got a 482, then yes, they can apply to be included as a member of family unit for the 186 TRT. So yes, they have that deeming provision, provided they still hold the 482 at the time of application. A lot of them don't hold the 482 anymore because they've turned 23. All right, question 1 with the 482. So they had a 482, the child was born while they still hold that, so that's George. And in the meantime, before the expiry, they lodge another 482, and that's what's pending. And it's only John and Jenny are included, and George here is now unlawful, right? Because he's not included in that 482 application. Okay, because he didn't have a passport. So how do we add him? So we can't add him. Good. So we have to do a subsequent entrant. Okay, how do we lodge a subsequent entrant? We need to meet your Schedule 1, so we have to get a C first. Okay, how do we get a C? So we have to do a subsequent entrant for 482, but we need a bridging visa C. How do we get a C? What are the options to get a C? So there's a couple of comments about waiting for the 482 to be approved. Just so you're aware, you don't have to wait until this 482 is approved. You can do a subsequent entrant anytime during the pending application. So ideally, yes, you could wait for it to be approved, but for the 482, you could lodge anytime. It is different to a 485. So the graduate visa, you would have to wait until that's approved to then do the subsequent for the partner. But for the 482, you can do anytime, right? So the child is not on an A. The child was on an A. Oh, well, the child did hold the visa. Up until the 482 expired, but the child was not included in that, and so they don't have an A. So that's why the child's on law. Okay, so we don't have an A for the child because he was born when they didn't have a pending application. Okay, so that's why, right? So child was born 2 months ago and the application was lodged 2 weeks ago and the child was not in the application, so it doesn't have the A. So we have to get a C. Only way to get a C. Why didn't John and Jenny include George? Exactly, like why did they not include them? If they just included them, we wouldn't be in this situation. But a lot of people who like to lodge their applications don't realize you actually don't need a passport to lodge the application, but they thought they needed one and that's why they were not included. Yeah, so the 482 application form includes an option for a person without a passport. So they must not have filled that in and that's why they didn't include them. Or where you don't have a passport for the person, in most cases, you could still proceed with the application, or you put in the passport of the mother, or you then put in a correct notification of incorrect answers to notify that we've had to put in the passport of the mother because he didn't have a passport, then that would still have been okay. So what if they wait to add child when? Yeah, so we can't add the child, we have to do a subsequent entrant, but to do that we need a C. The only way you can get a C is if you lodge, say, a 600, you get a C, and then you do another C, and then you lodge the 482. But you can only do this within 28 days of last substantive visa expiring. So if it was more than 28 days, then you've got to think of other visas and you might end up with some undesirable visa. But for the fact of just getting the C, it might be the only way to get around it. Okay, so have to think about what to do in those cases. Okay, I have included newborns in pending 482s on a number of occasions by contacting ESPT, who then adds child to records issue A and include pending 484. Are they doing the error? No, they're not. It depends on when the newborn was born. If the child was born during this stage, so if George was born here, then yes, he'd get an A, and that's correct. You add him to, it's added directly to the application. But the child was born while they hold their 482, so he gets granted a 482, but he was not included. That's why he can't get the A. All right, so what if they wait until 482 visa is granted, add the child, but then 482 is refused? Still can't add the child because he's not in the application. He just can't make a valid application. Right, to make a valid application, we need to get him on a C. Right, so the only way where he's not included in an application already, he has to lodge a subsequent entrant with a valid visa, a bridging visa, so a C. So visitor visa or maybe protection visa, though I don't like advising people getting protection visas. But if that's the only other one, there might be other visas, medical treatment, if you can get a letter from the doctor, whatever you could do to make a valid application to get a C to then lodge a 482, the only other way. Right? So we're not going to get that A ever for this child because it become unlawful. All right, question 2, would your advice be different if the pending application was a 186? Right, so 186 is treated differently, and someone's put up an answer here. Let's have a look. So 186, you got Reg 2.08a. Yes, so this allows a spouse, the dependent child, to be added to pending permanent visas. But the child also needs to satisfy Schedule 1, perhaps to this child, I kind of agree, but I don't agree. The child, yes, needs to satisfy Schedule 1 only in relation to location and not to do with the bridging visa. Okay, so just note your Reg 2.08a, right? I think it's 2.08a, yeah. Says you can add the child, but you only need to meet Schedule 1 in relation to location. Right? It's nothing to do with the bridging visa they hold, which is why an unlawful child can be included in a 186 that's pending, right? And we don't need to worry about that bridging visa C, okay? Because it's only in relation to location. It's got nothing to do with the bridging visa itself. So we've had people who are on bridging visa E's, right? Because of some other reason. Luckily, they're not 48 bad, and we can add them to a pending 186 as a dependent, right, as a spouse or, yeah. Okay, so that answer is half correct, but you don't need that bridging visa C. Okay. Question 3, would your advice be different if the pending application was a 494? So a 494 is what we call a provisional visa. It's one that would lead to a permanent visa being your 191. And the provisional visa has another ground in which you can add dependents. You could add a child under Reg 2.08b for a 494. And it's, I guess, the same process as your 186, where you've just got to make sure you meet the location part, right? So your 494, you can add a child. Your 186 here, you can add a child and a spouse, right? So there are some differences. Your 494, you can't add a spouse. If you want to add a spouse, you've got to do a subsequent entrant, right? So there are some slight differences with the different regs. So your 2.08a is good for your permanent visas, and you can have a spouse or a child, whereas your 2.08b is only for a child for provisional visas. If you want to add a spouse, you've got to do a subsequent entrant. Okay, and that means paying the base fee again. All right, so hopefully that makes Sense for everyone? Yeah, okay. Is that good? Should I add another layer of complexity? Sure, okay. Let's say it's not a pending application at the department stage. And George is born at a different time. Okay. So if we go back to another 482 and they've lodged it, it's been refused, and they're at the tribunal now. And George is not born until after the refusal. So we've got this pending ART. And let's say George is born at the time the ART is pending. What's his visa status then? Let's say everyone's got an A. So what visa status will George have? So the parents lodge a 482, gets an A.
The parents have,
The parents have an A, so George gets an A. Right. Now, what if the parents want to travel? Like J and J want to travel, and they want to get a B. So what happens to George's A? Can he? What happened to George? What will happen to George's A once the parents get a B?
oh, so you're saying it will automatically become a B?
No,
No,
something
more convoluted,
something you don't expect.
like it'll disappear.
Yeah. So George is granted the same visa as the parents, which was an A, with the same ceasing date. So if they go for a B, the A ceases. And so George is unlawful.
But why can't they include George in the B?
Does he have a pending application? No, he's got no pending application. So he's not eligible for a B.
Oh.
Wow. What's the solution? The solution would be before they lodge the B, so it doesn't cease, is he needs to lodge something, right? Like you could say a 482, technically, yeah. And then
A subsequent entrant for it too.
a subsequent entrant 482 because he's on a A,
Yeah.
right? Which is going to get refused, right? And then you can go to the tribunal.
Where?
And then you can get your B. Well, you can get your B anywhere, right? As long as you've lodged something, you can get your B, right? But he would need to make a substantive visa, otherwise he's not going to get anywhere. 600, ooh, maybe not because you got the 28-day issue. But he could lodge anything that could get refused, I guess, and then have that B, right? But if you don't lodge anything, it's going to cease and it becomes unlawful.
So, but that would be a very common, I think, scenario.
Yeah, and a lot of people don't realize by getting that B, it ceases. Yeah. So you maybe withdraw one of the parents and have one parent travel, the other parent still has their A, then it doesn't cease George's A, right? So you just make one parent travel, the other stays. Yeah.
As long as one parent stays.
Then he's still got the A because that visa hasn't ceased yet for one parent.
And is his A, how do they know? So it's linked to both parents.
Both parents, yeah.
Right.
So only one parent travel, the other parent stays on the A, so the child still has the same visa as one of the parents. Yeah. Okay. Let's say the tribunal says no, right? And they decide they want to go to court. What's the bridging visa for the parents? Well, you got to apply. for BVA. What about George? What's he going to get?
Doesn't have enough.
He has no pending application. So what's he going to get? An E. Yeah. So not great having kids during an appeal. Yeah. So just be aware of all these different bridging visa issues with kids, right? Yeah. All right. Quick other question. We'll skip Wally. We'll look at Danielle because there's another one. So Danielle is from Chile. She is currently on A at the tribunal. Her TSS was refused because a nomination was refused because it was not a genuine position. They've called a hearing. Business has been sold to an unrelated party. New owners are happy to sponsor her. Please advise. So can she continue with the current sponsorship nomination if the business is not there? No, easy. Can she apply for a 482 visa?
But
No. Can she go offshore? She can go offshore. And then any issues she's going to encounter? I don't know, bridging visas?
how BBB may not be granted.
So we get a B, go offshore, and then we lodge a new SBS, a new norm with the new owners, and new visa, 482.
Yeah. So
And
the
then-
BBB, if the tribunal says that, well, firstly, it will not happen in 2 weeks because tribunal takes time even after the decision. You understand all that stuff.
Okay, yes.
But let's say it arrives the following day,
Yeah.
the BBB will still continue for another 35 days.
Okay, so she comes back onshore. What's her status? B, okay. And if the tribunal case is almost finished, how do we
Another B,
link to another B? Yeah.
or she gets a C, and then she gets a.
Will she get a C? This is offshore.
She won't get a C.
She won't get a C. No C, but she could
C, she gets a B.
she could get a B linked to
Yeah.
the offshore 482, provided they grant the B within the time frame of the tribunal case,
Yes.
while she's still got that pending, yeah.
They may even say there are no substantial I don't know.
What if, you know how they're granting 5 years? Do you think they're going to grant another one? Who knows, right? It's going to be a tricky one. Maybe they're doing that on purpose so that there's no reason to grant you a further B because you still got 5 years.
But if you're not granted a further B, that's why that's how they, that's their.
We don't know, right? We don't know. I don't want to. I guess if you're in that situation where your tribunal case is withdrawn, then you can say, well, it doesn't matter that my B is for 5 years. It will cease once my tribunal case is over. Right, yeah. Okay, so Danielle withdraws the tribunal case. She's sponsored on the 482 under the new sponsor. So she's got that pending application offshore. Now the nom's been refused because no contract. So her 482 is going to get refused. What can she do? So this is gone now, like this is finished. She's got the B here, but this is going to get refused. Can she stay? Can she stay?
Well,
She got review rights or not? It's too hard. It's too late in the afternoon. It's too hard to think, right?
the nomination needs to be appealed.
So we lodge an appeal here. What about this visa?
She applied for it from offshore,
Mm-hmm.
so no, right? Coming back to you.
Yes or no? Offshore. Who's going to appeal? Okay, so our norm, we go to the tribunal. It's the SBS sponsor, appeals the norm. Yeah. Who's going to appeal the visa for an offshore one?
The sponsor.
The sponsor, right? So the review,
Yes.
yeah. So the review applicant needs to be the sponsor, right, for the visa. And we've got to make sure we do it within the time frame. We've got that Section 57 requests. We had the 28 days. The nom's already appealed at the time of decision for the visa, right? So we're good with that. So can she stay? Can she stay?
The tribunal, yes.
Are you sure? I'm not saying you're wrong. I actually agree with you that she can stay. But why can she stay?
If she goes, if she will then continue the 482, sorry, the BBB will simply continue.
Yes.
So long the ART is lodged on from the nomination and for the visa.
Yes. So even though the 482 was lodged offshore, she got the B. So the B will continue until it is finally determined. So what does finally determined mean? When the ART has looked at the case, right? So the B will still continue. She can stay, even though it was an offshore application, even though the review applicant was not her, but the new SBS sponsor. All right, so she can stay. Not too bad. It's good for Danielle. She has options, right? She has options. Okay. Question: what if it is a 186 lodged offshore? Same sort of thing. So you could still get the B tied to the 186 lodged offshore. The review applicant is a problem, all right? So if it was a 186, we've got problems actually because we can't seek review. Can we? No, we can. Hold on. Let's say it's a 186. Let's work this out.
Oh, but wait.
Wait.
Sorry. The nomination was refused because the employment contract was not included at the time of lodgement.
Yeah. Have you not seen those refusals? Have you not seen those refusals? But it can be fixed at the tribunal stage. But not your LMT. Your LMT you have to include at time of lodgement.
That's not is that legislated? At the
Because
time of lodgement?
no.
No. She needs to be given a contract that doesn't say that it needs to be included.
Yeah, that's why it was refused, because she didn't include it. But you can fix that. It can be remedied at the tribunal stage once you provide them the contract.
Okay, but if it's, let's say, uploaded a day later,
That's okay.
that's okay.
Yeah. If it's LMT, you have to upload a company with the application.
Yeah,
that one's a no. Yeah.
This says a time of
Yeah.
lodgement.
Yeah. It's a time of lodgement at the time when they lodged that.
Okay.
Yeah,
So as long as it's provided and let's say signed
Yeah.
before the nomination was lodged, but provided a few days later.
It's okay. That's all right. That's all right. Yeah. The ones where they do refuse with contracts, not so much not including it, but it's dated pre-LMT. Yeah, those ones are genuine.
That's classic.
Yeah, all right. You got those issues. All right. Now, changing this to a 186, let's just work this out a bit because there are some technicalities with it. So if the noms refuse, yes, so your sponsor would review the nom. Now, the visa, it depends where she was at the time of decision. So time of decision and time of application. So for her, she is fortunate if it was refused onshore. So your 186, different to your 482, if your time of application you were offshore, the only way you'd have review rights is at time of decision you were onshore. So because she was onshore, she would be able to have review rights. So she seeks review and her bridging visa B continues. Right? But if she was offshore at the time of decision, then she has no review right. Okay, so slight differences with a permanent visa, though in this case, because she's onshore for the time of decision, she has review rights. Does that make sense?
Yeah.
Yeah. But if she happened to also be offshore, say she lodged it, got refused offshore,
The 186.
the 186, then she's got no review rights. But she's lucky that she's here.
Yes.
Yes. All right. Okay. So more confusion? Yeah. Mm. Yeah. Whereas let's say they refuse the 482 offshore, that doesn't impact on her because it's the sponsor that seeks review. Yeah.
So if the sponsor just seeks review, then they'll still link it, right? When they raise the case, they'll still link it. We don't need to do anything else.
No, we don't have to do anything. Yeah.
Okay.
For the 482. Yeah. For your 186, for her to have review rights, it's just she's the one actually seeking the review. Yeah.
And let's say if she applies for review rights and it goes unnoticed, and at some stage it will just come back invalid, right? By the tribunal. The tribunal will say there's no jurisdiction.
So say that again. If
she's the one seeking review rights.
On the 482, yeah.
Well,
Yeah, and then the tribunal will say we've got no jurisdiction because you're not the one who's supposed to be the review applicant. No. Yeah, and then she'll be out of time anyway. By the time they look at it, yeah, and then say you were not the right person seeking review, and so too bad. Then she could still go offshore and redo it again, provided she's still got her bridging visa B to travel and resolves this within 35 days again. Like, so it's interesting, right? Okay, any other questions? There's a few other slides I forgot about. Yeah, NIV, which I won't go into too much detail. It's all on the department website, so you can have a look at that. Some of the state governments are open. Victoria, New South Wales, and Queensland, I think, are the main ones.
Tasmania
Something. Queensland. So I was at the LCA conference last week. Queensland, they said they haven't invited anyone yet. So they're still working it out. They know what they kind of want, but they haven't really told anyone what they want and who they want, and can't give us any examples just yet, but they are looking at whoever meets the department guideline. So it will be interesting to see who gets invited. So that's all your NIVs. Just slight changes with the family violence provisions. It applies to permanent visas, so not your 482. So if you have that situation where the relationship breaks down with the primary and the dependent, unfortunately, your 482 dependent is going to have their visa cancelled unless they find another pathway. They can say it's family violence, yes, so they'll delay the cancellation, but they will need to find another pathway. Unless their visa's coming up soon, then they might not cancel. So
858 is included.
the cool talent, or the NIV, yeah. Yeah, it's like all your skilled visas as well. So how's that going to impact on your points for your 189? You're in a partner relationship. You get the point. You split up. Family violence. Is that going to change your points?
You have to meet the points at TOA
And time of decision.
and time of decision.
So if you're relying on the partner points and you're not in a relationship, and then you got family violence, and then are they just going to ignore or treat you as single and you get 10 points?
Yeah.
Or
But if you can get the single points,
you can't add your partner if you're single. Or you could, like if they've got all to meet up 10 points, right? But then how would they treat it at the time of decision where, yeah, who knows, right? We'll see. The worker exploitation workplace justice visa. So if there are any issues, it's a 408 visa, and you've got to apply within that 28-day time frame, and you need one of these certifying entities to confirm its workplace exploitation.
Where does that lead? Nowhere.
Nowhere. Well, you need to have some sort of court proceeding or civil proceeding on foot.
Yeah.
Yeah,
And
complaining
it's
about
not
the
a sponsor,
employer.
it's just a.
It's just 6 months to keep you here to sort out your fair work dispute.
Right.
And then you'll have to move on to another visa. Yeah, and it's not available to existing 482s that have another year left on their visa. So if you want to claim workplace exploitation, you can't jump onto this visa until 28 days when your visa's about to expire. So you can't do it if you've got a year or 28 days or more left on your visa. You can't apply for this visa.
Oh.
So, anyway, so it's a little bit limiting. Yeah, so just be aware of that. Okay, and just the ministerial direction on processing. So we've been told and clarified by the department that this only applies to those visas, not the SID. So the 482 reference here is for the TSS. So any regional healthcare teaching, they will get priority for a TSS and a 186, but not your SID visas. So the SID visas are based on whether you're that high income specialist skills pathway or not. So that's how they're doing their processing, and then time or when you lodge. And that's why they're taking 6 months or longer. All right. And that's it. I think we're good. Any other questions? No? So there's a couple of questions on the Q&A. So I think I've covered most of these things. Okay, so there's a quick question, but I'll read this out. The applicant lodged a 407 visa in August 25, which is still pending. The BBA in association with 407. Applicant applied for BBB in order to depart, and that B was valid until November 25. In March 26, lodged a 482. Then applied for a B in connection to 482. However, the system shows the 407B is active while the 482B is not active. Okay, I've checked Vivo and it still shows the B expired in November 25. Can you confirm if the department, or if the applicant departs now, the B linked to the 482 will become active? Okay, so because you still got a 407 that's pending, that B to the 482 is not going to be active until your 407 has been finalized. So they still have the two Bs, so they still hold that B. So once you sort out the 407, if you withdraw that, then the 482B will come into effect after withdrawal, 35 days after withdrawal. Okay, so they still have it. That's fine. It's just Vivo will show the earlier one because it's still there. All right. Any other questions? You've got my contact details. Send me an email. Good luck with all these cases. Hopefully you learned something which may be useful one day. And yeah, so if there's anything, let me know. And all the best. And tomorrow, I think you've got Dennis and Keith to talk about the core skills and character cases. So good luck with that. And hope to see you guys next time. So see ya. Bye. Oh, and we do have a feedback form. So if you want to fill that in, that would be great. It just gives us, ideas as to how we can better improve these workshops. But all the best. We'll see you next time. Bye.